damaging the right under Article 19, well, that apart, there is nothing in CL. B. To prohibit principles of natural justice which are part of the law of the land wherein the rule of law reigns supreme, from being applicable when the liberty of the individual or his property is affected by a law, Pylon 24 to 526 R. Cooper v. Union of India, 1970, 3 SCR 530, CU of W 111, Bentov M. and Bela Banerjee, 54, 3 SCR Imamintior, P. Vajraulo Mudaliar VSPIOL, D. Philly Collector Madiar GJ Ainar, 1965, 1 SCR 614, Union of India, Vithai Mel 41, Corpo Wian of Indio Lid, O'Neill Anar 967, 1 SCR, 255, Sel D Alt of Guj 11 R 1 V, Shanlilal Mon 1 L 01 or 1, 9693, SCR 341, Cooptar VTAI Vlad Ward A Board of WeArc 1, 14 CBNS 180, referred to new Art 31C is only valid if the words inconsonant with or takes aware. The words 11 are tied 1T in the declaration portion and no law containing a declaration that it is for giving effect to such policy shall be called in question in any court on the GRound that it doc not give it as such policy arc severed. You they arcs heavy crubble what remains after severing can be Oprah Court Reports 1973 J sub SCJ operative and effective on the interpretation given to the applicability of Art and 31 so as to enable laws made under Art 31C to further the directives enshrined in Art 39, B, C, 503, the directives under Art 39B and C arc-wide and indeterminate itis xeri, to keep in the docta field of governmental activity enjoined in I, Article 39B and CMD term MG the RACCB of the means to achieve the ends and the impact of these means on the fundamental rights which Article 31 CAFEX thought a core have no function in the evaluation of the policies of the state or 1ND term 1 and ones whether they are good or bad for the community. They have, however, in examining the legislative action taken by the state in furthering the ends to ensure that the means adopted do not conflict with the provisions of the Constitution within which state action has to be confined. 35, 536. Article 31C has 4 elements. I. It permits the legislature to make a and IV, it prohibits the calling in question in any court. Such a law, if it contains a declaration that it is for giving effect to the policy of state towards securing the principles specified in clauses B and C of Arty 39, on the ground that it does not give effect to such a policy of the state. The first clement would be UTRJJ Vim, the amending power conferred by Article 368, if it deals within it the damaging or deconstruction of the fundamental rights. The second, namely, taking away of the fundamental rights, would be Thrivim, the amending power for taking away of these fundamental rights is synonymous with destroying them. The third, namely, abridging of these rights, is not the same thing as damaging, and the validity will have to be examined and considered separately in respect of each of the fundamental rights, and abridgment ceases to be an abridgment when it tends to have sacked the basic or essential content of the right and reduces it to a mere right only in name, and in such a case it would be ultra vires the power under Article 368 insofar as Article 31C authorizes or permits abridgment of the rights conferred by Article 19. It would be intra vires the amending power is thereby damaging or emasculating of these rights is not authorized. 537-53. The guarantee of equality in Article 14 has incorporated the principle of liberty and equality embodied in the preamble to the Constitution. 2 concepts are inherent in this guarantee. 1. Of equality before the law, a negative. The negative content on the positive aspect has not so far been clearly dissected in the decisions of this court, which has been mostly concerned with the Puiti v. Winnipeg Capre D8 539. The lifting of the embargo of Art 14 on any law made by Parliament or the Legislature of a state under Art 31C would abrogate that right allure. It may be that the objective of Article 39B and C may form a basis of classification depending on the nature of the 1 for which it was enacted and the impact which it has on the rightal of Siazin, but the right to equality before the law and equal protection of laws in Article 14 cannot be disemboweled by classification, insofar as the abrogation of the right conferred by